In this presentation, I cover Chapter 3 of the book titled Human Rights: The Quest for Dignity. This chapter examines several rights and obligations of states under both political and economic rights conventions. In this presentation, I mainly focus on two of those emphases, the rights of refugees and the rights to be free from torture. The remaining rights, including the right to food, the right to health, and the right to an effective redress and adequate remedy, are introduced. In the coming weeks, we will look at each of these rights, starting with torture, and examine the empirical and historical record related to conventions aimed at ending those abuses. The right to be free from torture is one of the most widely recognized and accepted human rights. The prohibition against torture exists in several international, regional, and domestic legal instruments, including the Universal Declaration and the Political Covenant. This discussion centers around the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, also known as the Torture Convention. The definition of torture is any act by which severe pain or suffering, physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain and suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. It does not include pain or suffering arising only from, inherent in, or incidental to lawful sanctions. So, for something to be torture, it has to be severe, and this is seen as a separate form of treatment than what is cruel and degrading or inhuman. Although the three were viewed as one and the same until the 1978 decision by the European Court of Human Rights in Ireland v. UK, where the court ruled that 5 techniques, wall standing, hooding, subjecting to noise, deprivation of sleep, deprivation of food and drink, did not constitute torture, but did constitute cruel and degrading treatment. But recent history begs the question of when pain and suffering is severe enough to be classified as torture, and this is one of the questions raised repeatedly by the Bush administration in response to criticism of waterboarding. The Bush administration tried to redefine torture so that only treatment whose consequences could be death, organ failure, or permanent impairment of a significant bodily function would constitute torture. The administration also sought to establish the idea that when the president acts as commander-in-chief, he is not bound by domestic or international prohibitions against torture. The fact is that torture can be mental as well as physical, and a final requirement for torture is that state action be involved, or if the state has a policy of allowing private acts that constitute torture. As far as domestic obligations, countries must take effective measures to prevent acts of torture in any territory under their jurisdiction and must make torture punishable, investigate allegations of torture, and establish a mechanism for victims to have enforceable and adequate compensation. Moreover, they have an obligation to train police and security personnel to not use torture in the process of carrying out their duties. In addition to the United States' grave actions at Abu Ghraib, the United States' treatment of its domestic prisoners has been investigated, and United Nations experts, as well as American Civil Liberties Union experts, have warned that this type of confinement, solitary confinement, may amount to torture. Empirical evidence suggests that the signing of the Torture Convention does not ensure against torture as a political tool. 81% of states were found to have violated the convention in the same year that they signed the Convention Against Torture. This is different for states who create both institutional and cultural commitment to honoring international agreements. There are 4 state obligations that are extraterritorial when it comes to the treaties related to torture. The first is non-refoulement. The second is prosecution and extradition. The third is the interstate complaint system. And the fourth is the right to an effective remedy and redress for those who have been tortured. Article 3 of the Torture Convention states that no party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. This is an absolute principle that protects everyone, even those who have fled justice for committing human rights abuses. This has been challenged by Canadian Supreme Court, who ruled that deportation to places where torture occurred should not interfere with carrying out immigration law and its own interests of national national security. The Human Rights Committee and the Committee Against Torture have sharply criticized this decision. The practice of extraordinary rendition has severely tested the meaning of Article 3 as well, as several Western states have engaged in far-ranging programs resulting in suspected terrorists being sent to countries where torture is more commonplace. Another obligation is the obligation to prosecute all alleged torturers or extradite them to a country that will prosecute. This applies even if the country has no connection to the victims and if the torturer is a national of another country. The legal obligation arises from the alleged torturer's presence in their jurisdiction. This is what is meant by universal jurisdiction. In the United States, the 1994 criminal law that prohibits torture was used to prosecute the son of former president of Liberia, Chuck Taylor, who was convicted of torture of civilians in Liberia. A similar case transpired in the UK, where a former Afghan warlord applying for asylum was arrested and convicted of conspiracy to commit torture and other crimes against Afghanis. He was sentenced to 22 years. The final extraterritorial provision is the interstate complaint system. This allows a state to file a complaint against another state on the grounds that the latter is not fulfilling its obligation under the convention. To date, not a single complaint has been filed under Article 21. The right to an effective remedy for those who have been wronged is another element of the obligations, but as the text points out on this matter, obtaining this measure runs into many problems. However, there are a few cases where both the right to redress and effective remedy related to torture were met by states. The Fil-Artiga principle relates to the story of Dolly Fil-Artiga, who was a Paraguayan national living in the U.S. when she received knowledge that her brother's torturer and killer was visiting the United States. She filed a private civil complaint against him, and the Second Circuit Court of Appeals held that the prohibition against torture is universal and that foreign nationals who are victims of torture can sue under federal law. This is also known as the Alien Tort Statute, when those who are responsible are present in the United States. The family was awarded $10 million, but have not collected any money from the defendant. In addition, there is the Pinochet principle. This was when an international effort to prosecute the former Chilean dictator culminated in his arrest during a visit to the UK. This was at the request of the Spanish magistrate seeking his extradition for torture against Spanish citizens who had been present in Chile during his presidency. But this is not a common practice, with plenty of examples of former torturers living out their golden years abroad. But the ICJ has also ruled that sitting government officials are immune to such proceedings at the domestic level. They can only be prosecuted by the ICC or some other form of international tribunal. Both Chucky Taylor and Omar Hassan al-Bashir of Sudan have received judgments against them in these types of tribunals. Al-Bashir is the only indictment handed down from the ICC so far. The Special Court for Sierra Leone convicted Chucky Taylor and handed him 50 years in jail. The argument that torture is justified when performed in the name of public safety has been proposed by many, including the findings of the Israeli Supreme Court and the Public Committee Against Torture versus Israel. Defenders of the practice appeal to the ticking bomb argument, which represents a hypothetical situation where someone held in custody knows the exact whereabouts of a bomb that will harm millions, and the only way to extract this information would be through an immeasurable amount of pain and suffering. There are a number of problems with the logic and the empirics of this question, such as the fact that the person in custody could be the wrong person, that person may give bad information just to avoid torture, and the alleged widespread use of this tactic at times indicates that torture is most often not used in the time bomb sense, but in the punishment sense. And this, say experts, can lead to a new generation of terrorists that seek retribution against the state that sanctioned the violence and trauma they experienced. The implication is that torture itself can cause more human rights abuses in the future. Refugee refers to a person seeking asylum under specific conditions. These are people who have lost human rights protections in their own country. Article 14 of the Universal Declaration provides that everyone has the right to seek and enjoy asylum from persecution. Asylum is just another word for refugee protection. Although an individual has a right to seek asylum, no state has a legal obligation to provide protection, but they are obligated not to send a person back to a country where their well-being or life would be threatened. This is the principle of non-refoulement. In order to qualify as a refugee, the claimant must be outside of their own country, must establish that they have a well-founded fear of persecution, and that is based on race, religion, nationality, or membership of a particular social group or political opinion. Refugees who cannot live may still be in a refugee-like situation in their home country. They are referred to as IDPs, or internally displaced persons. There are more IDPs in the world now than refugees, and some states like Iraq have large numbers of both. The second requirement relates to the interpretation of the meaning of well-founded. A claimant must prove future harm if they return to their home country, but also they have to provide evidence of past persecution. In addition, there is no standard risk necessary in order to be well-founded. The general rule is that the claimant must show a real chance or reasonable possibility of being persecuted. Another question that inevitably arises is what constitutes persecution. There is no universally accepted definition, and it can be inferred that threat to life or freedom is included. Commonly, we think of persecution as involving imprisonment or violations of physical integrity, but persecution can also include other forms of ill treatment. But no agreement on the severity needed to constitute persecution exists. States privilege violations of civil and political rights over economic ones. Thus, people fleeing economic deprivations are called mere economic refugees and often do not get asylum based off of these claims. Finally, in order for a refugee to be considered a refugee under international law, the requirement is that the persecution be related to the 5 categories mentioned. And membership in a particular social group is extremely vague, and there is no indication of how far this extends. The most common view is that such a group shares some common immutable characteristic. Gender persecution has created a problem, as U.S. authorities have at times recognized gender as a group, but at other times it has not. And here we just have some comparative data from 2007 forward discussing the growth in refugees, both internally displaced and externally displaced, since 2007. Article 3 obligates states to avoid refoulement in any manner whatsoever, including direct and indirect actions or omissions by the state. But this only prohibits returns to territories where applicants face serious prospects of harm. It does not prevent the state from sending them to a different country. And the responsibility for taking in asylum seekers has often been denied, especially in Western states, through the first country of asylum principle. In other words, if an individual has passed through another, quote, safe country to arrive in your country, then that country often will turn them back to the previous country. There's also the practice of creating a safe country of origin list, which is created by states individually and automatically precludes an asylum claim coming from that state unless there are different evidentiary standards that are applied. As far as extraterritorial rights, in addition to non-refoulement, states have an obligation to stem refugee flows, and this is also obviously highly contested. The U.S. holds that unless a person is on U.S. territory, they cannot claim protection against non-refoulement. So this has been the rationale for returning Haitians who were seeking asylum back to Haitian territory. A very similar situation is faced from those who were escaping the Middle East in the Mediterranean to get to Europe. The right to health is recognized by many treaties and covenants and is treated as a separate right under the Economic Covenant, but is connected to many other recognized rights. As the text mentions, some women have a 1 in 10 chance of dying during childbirth, depending on where they live, and some estimate that around 6 million children die each year from preventable diseases. So some ask how this is not a human rights abuse on a massive scale. It's considered an economic right that states have an obligation to, quote, progressively instead of immediately meet. While the previous chapter and future readings will confront the question of extraterritoriality, the main obligations have been given to the state. Even though some health issues are on a global scale, such as AIDS and HIV, and recently COVID-19, which is a global pandemic, how you relegate something of an international nature to a state or even local level to administer is an ongoing question and controversy. The principal obstacle to enforcing the right to effective remedy relates to immunity of heads of state and sovereigns.